Indians. Mr. velie will argue, if I understand his argument correctly, is that the Cherokee Nation should not be an Indian nation composed of Indians. It should be a nation composed of historic classes of people associated with the Cherokee Nation. The real question, to me, is who makes that decision? The federal courts, the United States government, or the Cherokee people? That is the most inherent right of sovereignty, recognized in the world community, even under the Convention for the Rights of Indigenous People, to determine your own identity, to determine your own citizenship.
Thank you, Chief. Attorney velie, is this an issue of blood and identity, or is it an issue of money being paid by the Cherokee Nation to the freedmen?
It's an issue of identity. Being a Cherokee is a birthright. That can't be taken away by your temporarily elected officials, especially when that birthright is guaranteed by treaty. That's what this is all about. We didn't bring a claim for any money at all. This is a declaratory judgment. No one's seeking retribution or any of those sort of things in our lawsuit. We're merely seeking that all Cherokees be treated equally, and that includes those that are protected by treaty, which are the freedmen.
Don't sit down too quickly. The next one's for you, too. Your plaintiffs had said to the news media that they would drop the lawsuit in exchange for their right to operate a casino. How do you respond to this?
That's not true.
I like it simple. Yeah, that's good. For Chief Smith, where do you get the figure that only 2% of the Cherokees own slaves? What are your sources?
The early censuses in the 1830s to 1860s, I believe, showed 229 slave-holding Cherokee families. And that was a population out of a population of 16,000.
Attorney velie, the Cherokee Nation, as a sovereign nation, has a tribal court system that has ruled on these issues. What do the federal court plaintiffs think about the tribal court proceedings?
There are tribal court matters that are going. We're not involved in that. This is a federal lawsuit because there are two governments that signed a treaty to protect the rights of the freedmen. We cannot pull the United States government into the Cherokee courts. There's only one court system that we can try both of the officials of both tribes, and that's where it stands right now. Our lawsuit right now is against the head of the Department of Interior and the chief of the Cherokee tribe. We've asked to include the Cherokee Nation back into that lawsuit. We can find redress against the tribal officials, and the declaratory and injunctive relief we're seeking that those people cannot act outside the sovereignty that their nations have given them as officials. And the sovereignty that each nation has given those officials is that there is a treaty. It's still in full force and effect. It's been decided by the courts. And that you cannot have laws exist within your country, which either one it is, that discriminate against that treaty. That's where we're going with that. That's where we're going to find our relief. Thank you.
Great. Question for both of you. And there are actually several questions, but they all have to do with the notion of using DNA testing to determine tribal citizenship membership. What are your thoughts on DNA tests?
This is a good question because it distinguishes very clearly what an Indian is. An Indian under the law is not a racial group. There's a 1975 case, Morton versus Mancari. It was brought to challenge invidious racial discrimination by the Bureau of Indian Affairs for Indian preference. This because you did have Indian preference. So you had a class, Hispanics, whites, blacks, Asians, who challenged the Indian preference. Went to the Supreme Court. What did the Supreme Court say? It's not invidious racial discrimination. It's not even racial discrimination. It's political discrimination because these are, under the law, Indians are subjects or citizens of a government. It's political discrimination, which is not prohibited. So a DNA test will show you heritage. It will not establish this inherited political right. being a citizen of the Cherokee Nation based upon a base roll in 1906.
DNA is interesting. It's a science, right? And how does science really apply to other things is an interesting question. And I think it's difficult. How would you tell the DNA from a Cherokee, from a Choctaw? I don't know that that science exists to that state. So in our case, it's not even relevant because we're talking about a finite group of people. The freedmen are the descendants of those people who were on the Dawes rolls. No more. No other people. These were the people that were determined in 1906 to be the stakeholders, the citizens of the Cherokee Nation that received the same lands as the other citizens of the Cherokee Nation. That's it. All you got to do is go back to those rolls to find who were the citizens at that point, and everybody that derives from them, or anybody that derives from them, are descendants of the Cherokee Nation. This is a very simple case. We have a treaty, we have a roll. Connect the dots, and we have our citizenship. We're fighting over something and making it much bigger than it really needs to be. It's hurting the nation, and it's putting a bad image, I think, on this whole issue, and we need to put it behind us. I don't know if that answers the question on DNA, but I don't think it's relevant for our point, and I think it's a tough science right now to figure out what the answer would be anyway.
Thank you. Another question for the both of you, starting with Chief Smith. To what extent does the Treaty of 1866 constrain the Cherokee Nation from defining citizenship as they will? If it does, can the United States government determine tribal citizenship for all tribes in all cases?
It's interesting, the Treaty of 1866 was pretty much nullified 4 years later in a tobacco case. It's sort of interesting. The federal courts, the Supreme Court said, whichever comes later in time controls.